In social media news, the Supreme Court has decided to hear twin cases from Florida and Texas relating to social media censorship and whether states can stop the social media censorship. We have covered this case before, principally the Texas case. We covered it in its case in the district level and also on the Court of Appeals level. And I thought, that the Texas law looked like it might actually withstand scrutiny. The Florida law had some problems in its way it was written. So they were both trying to do the same thing on some level, prevent social media companies from discriminating against viewpoint about who could, say what viewpoints. But Texas's was more cleverly drafted, at least in my opinion. And I thought the Fifth Circuit opinion might withstand scrutiny. Well, I guess we're going to find out now whether or not I was right. So it's because the Supreme Court has decided to take review of these cases on whether or not states can force social media companies to stop discriminating on the basis of political viewpoint. Can states do that, or is that a First Amendment violation? Okay, let's learn more. The Supreme Court on Friday agreed to take up cases originating from Texas and Florida that would regulate how large social media companies like Facebook and Twitter can control content posted on their sites. The laws were enacted in 2021 in response to the legislature's belief the companies were censoring users on the basis of viewpoint. The companies contend the laws violate their First Amendment rights. So that's sort of where we're sitting. On the one hand, the legislature says, okay, social media companies, it seems to us that you are taking action against people because of their protected viewpoints. And the social media companies say for their part, but we're not the government, and we have a First Amendment right too, both in freedom of association and also freedom of speech, and also freedom of press, I suppose, incidentally. So we could even make it a First Amendment trifecta, that we have some rights that enable us to not post content we don't like for whatever reason, including political viewpoint. So that's the fight, right? It's like, do the social media companies have to host this content? Do they have to transmit the content? And there is some case law that suggests the answer might be yes. Okay, so there is, the fair report doctrine, which isn't a law anymore, but did exist for a time, that the Supreme Court upheld, incidentally, back in the 1980s, that at the time required broadcast TV to give equal time to different political candidates. So if you had the one political candidate on, you were required to have the other political candidate equal time. That was something that was upheld by the Supreme Court in the 1980s with respect to broadcast TV. And also there's some cases from as far back as the telegraph era dealing with states trying to force the then nascent Western Union Telegraph and forcing them to carry messages from providers they don't like. And Western Union saying we have a First Amendment right, and the court saying no, because you are merely the transmitting tool. You don't have a First Amendment right in the transmission. You're merely a courier, basically, in so many words. And so you don't have a First Amendment right because it's not your speech, Western Union. You may be the one transmitting it, but it's not you speaking. So it's not your First Amendment. And you're discriminating, and we have the right to, prevent that. And the courts upheld that too. So, that's part of the issue. And then, of course, you have Twitter and social media come along and say, okay, are you like a Western Union Telegraph? Are you like a broadcast TV? Or are you like something else? So, yeah, it's a very interesting First Amendment case, to be sure. Yeah, we'll see how it goes. The announcement that the Supreme Court has decided to grant this case in the form of Moody versus NetChoice and NetChoice versus Paxton came as part of a list of orders. So NetChoice is suing in both cases. In one case, the decision was that it was unconstitutional. In the other case, the decision was it was constitutional. But there are reasons to believe both those things are true. Because Florida's law and Texas's law were not written the same. And so it is very possible that Florida's version of this was unconstitutional, but Texas's version is constitutional because of some material differences in how the statute was written. So the 11th Circuit said Florida's version is unconstitutional. The 5th Circuit said Texas's version is constitutional. They might both be right. We'll see as the Supreme Court decides to grant these twin cases for review. The Texas and Florida legislatures passed the laws at the center of the dispute in 2021. The Texas law, known as HB 20, bars social media platforms with at least 50 million active users from blocking, removing, or demonetizing content based on viewers' views. The Florida law, known as SB 1072, or the Stop Social Media Censorship Act, prohibits social media companies from banning political candidates and journalistic enterprises. So, yeah, technology companies went to federal court in Texas and Florida to challenge the laws, arguing, among other things, they violated the company's rights to the First Amendment because they say, well, first of all, we have a right to speak or not on our own terms, and you can't make us speak, and you can't make us not speak. That's in the nature of the First Amendment. You can't do that. Second of all, we have a freedom of association problem because you're forcing us to associate with people we don't want to associate with. And third of all, we have a freedom of press problem because we are a press, because we're a method of technological communication. And so they're like, okay, we have First Amendment rights times 3 that allow us to, prevent this from happening. The justices put on Texas's law on hold last year while challenges continued in lower courts. In an opinion joined by Justice Clarence Thomas and Neil Gorsuch, Samuel Alito suggested the court did not need to intervene yet. Kagan also indicated without explanation she would have allowed the law to go into effect. So you have 4 members of the court say, we are not so hot about this, but you only need 4 votes to hear the case. So you have 4 votes to hear the case, so we're going to do that. In September 2022, the U.S. Court of Appeals for the 5th Circuit ruled for Texas and upheld Texas's version of law, and what I thought was a very smart decision. Reasonably, in my mind, analogizing social media like Twitter to the telegraph of old. You are just a telegraph with some minor tweaks, which isn't a wholly invalid analogy. Like the person comes to the telegraph counter with their message and you transmit the message. Or the person opens their app and types it out and hits send. Either way, you are a courier transmitting the message. In the case of the telegraph, typically to one recipient. In the case of social media, typically to many recipients. But what's the difference? You're just the courier. You have to make many stops as opposed to one stop, but you're just the courier. So, I thought that was a pretty reasonable analogy. It could break down, but I thought it was a pretty interesting case. This, of course, prompted tech companies to return to the Supreme Court asking the justices to weigh in. Texas agreed the court should grant review and urged the justices to consider both laws at the same time. So Texas is also like, yes, please take this up, even though we won. And also, please take up Florida's case as well. Florida, for its part, had come to the Supreme Court asking the justices to weigh in after the U.S. Court of Appeals for the 11th Circuit blocked Florida's version of the law. Texas version legal, Florida version illegal. In January, the justices had asked whether to take it up. In a brief filed in August, the U.S. Solicitor General recommended the court take up 2 questions presented by the case. Whether the provisions in Texas and Florida laws that regulate tech companies' ability to remove, edit, or arrange the content appears on their platforms violates the First Amendment, as well as provisions that require tech companies to explain their decisions violate the First Amendment. The Solicitor General of the United States urges justice to strike down both sets of requirements, but told the justices there's no need for them to weigh in 2 other aspects of the dispute: the tech companies' challenges to provisions in Texas laws imposing general disclosure requirements on social media, and the argument that the laws were enacted to target large tech companies because of decisions regarding the conservative site. So maybe this was illegal. because it was First Amendment retaliation, but then it gets into whose First Amendment is it? Who's the one speaking? So there was an idea that maybe these laws were retaliatory, but then maybe not, because maybe there's no First Amendment interest being violated in the first place because you're just couriers. And so, there's that. Among other things, she explained both sets of courts of appeals rejected these arguments, so there was no division on those particular issues. And in order lest the justices follow the Solicitor General's recommendation to take up the first two questions presented in the case, but not other issues. So we're just going to take up the issues in which there is a division of opinion between the two cases. The court will hear argument next year. The dispute is the second one involving social media this year. In April, the justices agreed to decide a separate issue as to whether public officials are acting as the government with respect to their social media accounts when they block people on their personal social media accounts. An issue that's also been percolating because then President Trump blocked some people, and the left went crazy saying, you can't block people because First Amendment. And then some of the people on the left blocked people, including Alexandria Ocasio-Cortez, who said, President Trump blocking people is illegal, it's unconstitutional. And then she blocked people, which is always hilarious. But there is a dispute as to whether or not these social media accounts are private or are they government. So are these accounts personal or not? So are these official communication channels or are these personal communication channels? So when they block people, are they blocking people personally or are they blocking people as the government? So the US Supreme Court decided to hear that issue, which I'm sure will also be super duper fun. The Supreme Court taking up two cases that present that question in the form of O'Connor Ratliff versus Garner and Linkty versus Freed. So when, if ever, are personal social media accounts not so personal? That should be exciting to follow, I'm sure. The justices are also currently considering taking up a case, but have not yet acted on a case, a request from the Biden administration to block an order by a federal judge limiting communication between the White House and social media. There has been some allegations that the Biden administration and its various apparatuses, let's say, put pressure on social media to do things with respect to speech, which is a real problem, that the government might have improperly censored via private action, but because they were the one directing it, not so private. When the private social media company acts in concert with the government, suddenly, welcome, congratulations, you're now the government. So there's that problem. So the judge ordered that, there not be communication between the White House and the social media because they thought that there was a serious First Amendment problem. The Biden administration would like to continue their communications very much. White House district judge had ruled the federal government had engaged in a massive effort to suppress disfavored conservative speech. After the federal court agreed with the conclusion, it somewhat narrowed the scope of the order, but not completely. And Biden has asked the Supreme Court to intervene because we'd like to continue talking to the social media companies in an unrestricted way, having them do our bidding and it not be state action. So the Supreme Court is also deciding whether or not to take that case up, which if they do, that should be exciting as well. Thus, that brings us to the end of consideration for the moment about the Supreme Court taking up cases that we've followed in the past, particularly as it relates to Texas's version of the thing, a little bit less so with Florida's version of the thing. In the case, both states, to some degree and via some mechanisms, although the exact nature of the degree and mechanisms is part of the problem, they said various versions of social media companies, you can't discriminate against people because of their viewpoint. You must host the speech of people with the different political viewpoints. And the 11th Circuit said Florida's version was illegal. And the 5th Circuit said Texas's version was legal, both of which might quite possibly be correct. Those are quite possibly both correct decisions. But we're going to find out for sure, I guess, because the US Supreme Court has decided to hear these cases as to whose speech is it, for starters, And can the states impose these requirements, at least some version of them, on the social media companies and force them to host, platform, transmit, or otherwise distribute speech that they might not themselves personally agree with? So that's happening. And we'll see how those cases resolve in the near future. At least for the moment, that brings us to the end of discussion of this story.